Okay. Welcome back to the James Noble Law information about Australian family law under the isolation and lockdown situation with the COVID-19 pandemic. Our first little bit of information, we've been asked a lot about how the courts are working at the moment. James is going to have a little bit of a chat about that, so I'll throw it over to you.
Right, thanks, Charles. Many of our clients and people phoning in generally wanting information. Of course, we do offer a 20-minute free information session with our clients, or anyone wanting to phone in. We're able to give a lot of information to people in that 20-minute sort of conversation we have with them. All our conversations now, of course, are by telephone, or could be by video link, Zoom, or other means. However, a lot of the people and our clients, especially our clients, have been asking, what's happening to my matter? Or I've got an urgent application and I need to have it filed straight away. Can we get that done? Are the courts still operating? Will they hear my matter? Well, the courts, I'm able to say, are fully operating in a limited capacity, of course. For instance, the courts realise the importance of maintaining a service to people wanting family law matters dealt with. And of course, as far as families are concerned, as far as we're concerned, those matters are extremely important, and the court realises that. So in a limited way, they are able to continue looking after the matters before the court. This could be by telephone if it's a non-urgent matter, and a face-to-face appearance is not required. It could be by video link if that is able to be arranged. So if it's not an urgent matter, and for instance, the other day we had a call over, we're on the call over list for trial in a parenting matter, and there were a number of matters listed before the judge on that day. The judge was wanting to know, of course, how the matter was progressing, and if the matter could not be resolved, if it needed to go to trial. So the judge, just gathering that information, was able to do it by telephone. We were advised by the court that the court will open at 9:30, and that we will be contacted when the judge gets round to hearing our matter. So we were able to fully prepare for that call over, or that mention before the judge. In fact, I had all my relevant documents up on my screen on my computer. I had my submissions ready to be made, and all that could be done just over the telephone. So if it's not urgent, the court will hear the matter. In that case, because it was involving a child, the parties had come to some agreement, and each one was seeing their daughter. So the urgency was not there. It was just a final resolution on what the parenting arrangements were going to be. The judge realised that perhaps if these parties went to a mediation, that they might be able to sort their matter out. And I feel confident that they were very close in their offers that they'd made, because they were asked to make these offers to the court. They were very close in what they wanted, and I felt strongly that they would be able to resolve their matter if they went to a mediation and had some independent to help them resolve it. The judge therefore adjourned the matter for a period of 3 months and gave directions for the parties to engage in mediation. And we are presently arranging that mediation. So if it's a non-urgent matter, yes, that can be done. If it is urgent, say someone's taken the child and someone is seeking an urgent recovery of that child, then you can apply to the judge by email and set out your submissions as to why the matter should be heard urgently. The judge will consider those submissions, and if it becomes really necessary, the judge can do a face-to-face hearing, allowing the parties to attend before him. Now, there are strict requirements if you do have an appearance before the court. The numbers in the courtroom are strictly limited to 8 people, and of course the social distancing rules apply. You will not be allowed to go into the court until your matter is heard, and there are waiting areas outside the court for you to wait whilst you're waiting for your matter to come before the judge. So that's in a very rare and exceptional circumstance. The judge will allow the parties to appear in the court. You can only appear on those matters for an hour and a half, at which time the courts are thoroughly cleaned. Everyone leaves the court and the arrangements are made for the courts to be thoroughly cleaned before the courts reopen to hear the next matter. If, for instance, you have a meeting or a conference with a counsellor of the court, and those arrangements have been made for interviews, and these were made before the pandemic hit our shores, it's up to the counsellor who's going to be conducting that conference to advise whether he does want the parties, or he or she does want the parties before them, so that they can gauge the parties personally. And of course, obviously proper arrangements would be made. There would only be the parents and the children, if required, to go to those meetings. Otherwise, again, such conferences would take place by way of telephone or video link, by means of Zoom or other means. On a final hearing, again, the court will decide whether they will just do it on the affidavits or the statements of the parties and not require the parties to attend. They may require submissions to be made verbally, and in exceptional circumstances, they will have the parties attend before the court on a final hearing before the judge. So that's the way the courts have been able to deal with it. They are still operating fully. They're ensuring that people with family law issues are properly safeguarded. Thank you, Charles.